All rise. Oh yay, oh yay, oh yay, this Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this
Good morning, everyone, and welcome. We're very pleased to have a good group in attendance today, and we'll do our best to be on our toes at all times. We have 3 cases on the morning docket, and we will call them in the order in which they appear. The appellants and the appellees have a total of 15 minutes to present their arguments, and the appellants have the right to reserve up to 5 minutes for rebuttal. So when the appellant comes to the podium, after you introduce yourself, please let us know how many minutes to reserve, and we will program the clock accordingly. This is the second month that we've been blessed with the addition of Judge Jeffrey Usman to the Court of Appeals, but I mention it because just 2 days ago we had the formal investiture of Judge Usman, which was held at the Belmont Law School where he taught for 10 years. And it was a lovely ceremony, and we're very pleased to officially welcome him, but we've already been working him quite hard for the last month and a half, so he's not new to us. Are there any announcements? Hearing none, please call the first case.
Eisai Incorporated versus David Gerregano, Commissioner of Revenue, State of Tennessee.
Good morning, sir.
Good morning, Your Honor. My name is Joseph Longnecker, and I'm representing the Commissioner of Revenue in this matter. I would like to reserve 3 minutes for rebuttal.
3 minutes, very good.
There's a number of issues that were raised in the briefing in this matter, but I'd like to focus on the 2 which I think are essential to resolving the issues in this case. Are doctors end users or retailers of the drugs that they dispense in the course of the provision of medical services for purposes of the business tax? And did Eisai have a business location in this state? The correct answer to both of these questions is yes, and that resolves both the statutory and the constitutional arguments raised in this matter. So with regards to the status of doctors, the business tax, as relevant here, ends up being administered on 2 entities. The retailer, who makes the final sale, where there's no more sales for resale, and a wholesaler, who's the last entity that sells to the retailer. That makes the determination of where the link of transactions ends essential to the determination of who pays the business tax. And in fact, the retailer is generally taxed at a higher rate than the last wholesaler in the chain. And under Pfizer, previous wholesalers are not taxed. So there can be as many links to the chain before the final retail sale. It's only the last 2, the sale to the end user and the sale to the retailer, which are taxed under the Tennessee business tax.
In this case, do you believe the physician or the clinic is the retailer, the last seller?
No, our position, Your Honor, is that the clinic is the user of the goods. They're the consumer of them because of how the business...
Well, doesn't the patient pay the physician or the clinic for the service and the product?
The clinic, in many cases, they would break that down on the invoice, Your Honor. They would say, oh, okay, you're paying for, here's your complete bill. Among the things we're billing you for is the drug. Okay. This could create, however, there are other cases where one might get billed for items where you aren't billed, where it is treated as, where the contractors, for instance, are a good example of this. A contractor might bill you out separately for the items that they provide that they install in your house. But under the business tax, a contractor is treated as providing a service. They are the end user of the products. And I agree that there might be some, if this legislature had not provided further clarity, if all we were working with was the definition of a retailer and a wholesaler, there might be genuine ambiguity about whether or not a doctor is a retailer or not. However, the legislature...
Well, if the doctor or the clinic is not the retailer, then why was it necessary for the legislature to amend the act to exempt the tax on that transaction?
I think that as I said, I think it's ambiguous. I think one could read it either way, Your Honor, if the legislature had not made further clarity. I think that it appears that what prompted this was, in fact, a interpretation by our office in late 1983, I believe, that said, oh, actually, we're going to separate this out. Doctors are sellers of services, which are exempt under the business tax. It's usually services are taxed, but medical services are specifically exempted. But we're going to say they're also retailers of tangible personal property, and we are going to tax them on that. So because of this interpretation, it appears, the legislature said no, the items dispensed by physicians, dispensed by dentists, inserted or items that are inserted or affixed to the body, those are not tangible personal property, and therefore I want
to explore a little bit
Yes.
how ambiguity cuts in this case. In your brief, you're treating this in terms of the default of an exemption, and therefore being read against the taxpayer in favor of the state and in favor of imposition of a tax. Should we really view this as falling within the domain of an exemption? Isn't this part of just the taxing statute itself in terms of imposition of the tax rather than an exemption? And shouldn't ambiguity in the default be read in favor of the taxpayer rather than the state?
I think it's somewhat part of the issue here, Your Honor, is that because if this is a carve-out, it's not structured in the way that it normally would be because of it being put in the definition of tangible personal property. So that it's not part of the reason why we're saying that this isn't intended to function, like the trial court said it was, is precisely because it's not clear where it falls. It has a lot of features of an exemption in that it's a specific carve-out of like a narrow domain, as opposed to being the broader space of tangible personal property that's sold is, of course, generally taxable. But on the other hand, as you said, it's part of the definitions, which often is treated as being sort of a restriction on the scope of the tax. So it's not on the trial court's reading, it's not clear which one it should be, which is, I think, part of the reason for saying structurally this isn't intended to function like the trial court ruled it is.
Do you have any other decisions from this court or the Tennessee Supreme Court in which the definitional language has been treated as an exemption rather than as part of the imposition of the tax initially? Has this court done that previously? Has the Tennessee Supreme Court done that previously?
With regards to the definitional language at issue here, I'm not aware, Your Honor. I do know that there's some that I'm not aware of a case off the top of my head, Your Honor. So the business tax structure, that again, a sale is we're somewhat uniquely, the definition of wholesaler and retailer flows through the definition of a wholesaler within the Tennessee business tax. In fact, a retailer is defined as as essentially someone who does not predominantly make wholesale sales. And then wholesale sales are defined through the notion of a sale for resale. That what one is doing is one has a piece of property, the property that is in the hands of an initial seller, who we would call the wholesaler, who is then making a sale for resale of the property to a purchaser who then resells the property. And the last reseller is the retailer. So as I was saying, so that if we just had the definitions, it would be somewhat unclear. And there's been cases where the department has needed to make regulations to clarify, for instance, if contractors are sellers or are end users or resellers of the tangible personal property that they install in houses, or what is carpet something that's being resold, or is it being applied by a contractor in the course of providing a service? But in this case, the legislature did clarify. They said that items that are inserted, affixed, dispensed by physicians or by doctors and during the course of medical treatment are not tangible personal property. So there is nothing to be resold under the definitions of the business tax. The doctor, as a matter of definition, cannot resell tangible personal property because they can't sell tangible personal property. But then because of how the structure...
Excuse me, why cannot they sell tangible property?
Because the stipend... Okay, sorry, Your Honor, I did misspeak to some extent. They cannot sell when the items that they're inserting, affixing, or dispensing in the course of medical treatment, when those things are inserted, affixed, or dispensed, are defined as not being tangible personal property in the definition of tangible personal property. So even though it might seem like they're inserting, affixing, or dispensing, they can't be. And again, as I said, this isn't...
That seems to lean in the direction of a plain language reading of this just isn't taxable then. And how does the state move us away from that position? I mean, the plain language, it's just not taxable, tangible personal property.
I think, Your Honor, because it is stuff that it's under a certain condition, it ceases to be tangible personal property. Again, when the item is inserted, affixed, or dispensed by the doctor, is when it ceases to be tangible personal property. Otherwise, there's no indication that the legislature intended for this to be a backwards-looking sort of thing, where it's like, oh, they don't say this was items that will be inserted, affixed, or dispensed, or items that are intended to be inserted, affixed, or dispensed. If this was intended to be a broad exemption or a broad carve-out, however you would prefer to view it, from the business tax, then there's no statutory indica beyond. All that they seem to be talking about is when the item is used. And again, there's parallel cases when when we say, oh, the contractor is the end user of the goods, we're not saying that those goods cease to be tangible personal property throughout the rest of the transactions. It's just they sort of lose their character of tangible personal property in the provision of contracting services. I would like to go quick, I suppose, to speak a little bit more about your question, Judge Usman, that the structure of the business tax is based around the notion that we're going to, again, with regards to these issues, it's the seller, the wholesaler. And the definitions have predictable effects when you change them. These are all interlinked. You can't look at the definition of a wholesaler and fully understand it unless you look at the definition of a sale and a resale, and a sale for resale. So I think the better interpretation of when the legislature changes the meaning of tangible personal property is not that it intended to create a freestanding exemption that should be read in isolation from the rest of the definitional statute, but that it's intending to create a series of effects in how these different provisions work. That when you're no longer selling tangible personal property, that means that you're the end user of it for all functional intents and purposes, because there is no additional resale to keep the chain of transactions moving.
Is there no resale, or is it simply that the sale is tax exempt?
I would say there's no resale, Your Honor, because it says that a sale for resale requires there to be a piece of property, the property, service, or taxable item that is sold by a wholesaler to a retailer, and then the retailer has to resell that property. And in similar cases, we don't treat contractors who provide an integrated service as being resellers of the personal property that they install. They're end users. This is part of how the business tax is administered.
But contractors, they are not subject to this special statute, are they?
No, because because the services that contractors provide are taxable, whereas for medical services, the services are not taxable.
Right. So the two perhaps aren't a good analogy.
I think that they're a useful analogy because you have to treat these situations differently in the statutory language in order to accomplish the same effect. Because you can't just say, oh, this is medical services are exempt, because the language already said that. But that still leaves the question of, well, maybe the medical services don't fully integrate the use of the tangible personal property. Maybe there's some independent thing that's separate from medical services. And I think what this language accomplishes in a very concise way is to carve that out and say, no, there is no tangible personal property for the doctor to resell for purposes of this tax. Very briefly, I would like to go to the business location issue, that we do think that the taxpayer's argument is in essence that there was a warehouse that was run by UPS where they stored a significant amount of inventory over the course of the tax period, hundreds of millions of dollars. But the whole structure of the business tax is that it's a replacement tax for the personal property tax on inventory. I see that I'm out of time. Oh, I guess I have two
Very
more
good.
seconds.
We'll hear from you further on rebuttal.
Excellent.
Thank you. We're going to have show and tell, I see. Very good.
Sorry, came out a little smaller than I'd hoped. You may not be able to read it, but
I recognize Governor Wilder and Governor Alexander's signatures, so
My guess is only one of three on this panel can read that.
That's right. It's all in the materials you've seen. And we're going to split time with my colleague, Mr. Carter.
How much would you like?
About 3 minutes for Mr. Carter.
For 3 minutes? Whoops, excuse me, I've just made a mess. All right, we'll give you 12 minutes. Okay,
Thank you, Judge.
Thank you. Sorry, Judge McBrayer.
You need
Excuse me a
minute,
second while we clean up.
Yes.
Is this when I use the passive voice? A mistake has been made. Thank you very much. You're very kind. Now you have our full attention.
Thank you, Judge. May it please the court, my colleague and I are here on behalf of Eisai. This court should affirm the Chancery Court's ruling for at least 3 reasons. First, the Chancery Court's holding was correct. The drugs sold by Eisai to the specialty distributors were exempt because the Tennessee business tax has an exemption for drugs that are dispensed by a physician, and it's undisputed that Eisai's drugs in this case were dispensed by a physician during treatment. Second, even if the exemption only applies to sales by those doctors and doesn't apply to sales upstream from those sales, Eisai is still entitled to summary judgment because it was still making non-taxable sales to a wholesaler. Judge Usman, to your question, that's absolutely part of the imposition statute, and any ambiguity in the statute cuts against taxation in favor of summary judgment for Eisai. And third, as my colleague will explain, even beyond those 2 arguments that fully support summary judgment for Eisai, application of the tax to Eisai in this manner is unconstitutional, and Eisai has standing to challenge the issue on constitutional grounds. So, with respect to the first issue, that is that Eisai's drugs are exempt because Tennessee law exempts drugs that are dispensed by physicians during treatment. Undisputed facts support the court's holding. First, it's undisputed that Eisai sells
And let me ask,
high-value.
is it exempt based upon an exemption, or is it non-taxable? Who has the burden of proof, I guess?
Judge, I would say it's the best. We think that the Chancery Court was correct in finding an exemption, but even if it's exempt, even if the items are non-taxable because the taxing statute doesn't reach them, Eisai should still prevail. We should prevail on the ground that the Chancery Court held, or we should prevail.
But the Chancery Court did hold it was an exemption, which placed the burden on you.
That's correct, Judge.
Very good.
It's undisputed Eisai sells high-value, life-saving cancer treatment drugs through its distributors and specialty distributors. It's also undisputed that they made sales to 3 distributors that the department has deemed taxable wholesale sales on the basis that those drugs were infused in patients in clinics rather than dispensed to the patient to take it home.
Counselor, aren't some of the products creams that would be perhaps applied by a patient at home by themselves and not by a physician?
Yes, some of the drugs were applied in that manner. So there's no real factual dispute on this first issue, and the only question is whether Tennessee law provides this blanket exemption from the business tax for drugs dispensed by a physician during treatment. But certain drugs are excluded from the definition of tangible personal property. This is a copy of 1984 Public Act, Chapter 563, that added this exclusion provision from the definition of tangible personal property. That's now in Tennessee Code 67-4-702A23. Excludes, as the statute read, any materials, substances, or other items of any nature inserted or affixed to the human body by duly licensed physicians or dentists, or otherwise dispensed by them in the treatment of patients.
So I'm trying to figure out the operation of that. Let's take something like Tylenol. I stop by Walgreens. If I'm in a hospital, then a hospital is distributing the Tylenol to me. If I'm at Walgreens and I'm purchasing it myself, they're not. And is that Tylenol, does it become untaxable because it can be given to me at a hospital by a physician? If so, I want a refund from Walgreens. But
the application of this exemption, as the Chancery Court held, drugs that are dispensed by physicians are in the treatment of patients are exempt, and certainly the department's contention is that, that broad application of an exemption to this drug all the way up the chain, that creates these absurd consequences that the legislature couldn't possibly have intended. That's a question. We're here to talk about Eisai's drugs. It's really
Well, I'm trying to understand the impact, though, and how, under your reading, what in the world is Walgreens doing taxing me on my Tylenol? I mean, that is something that can be dispensed in a hospital by a physician, and is Walgreens errantly taxing me on that product? Is it non-taxable?
I think that's a question to be, the scope of this exemption that the Chancery Court recognized, I think it's a question to be resolved through regulation. The department needs to,
Sounds like you're saying the answer is yes.
yes, it can be. If there is an exemption for any drug that may eventually be dispensed by a physician.
Does it become a question of burdens then, and who has the burden of showing that it's been dispensed by the physician? Is that the level we should be looking at? That if it's sold to me at Walgreens, it's taxable, but if it's given to me in the hospital by the physician, it's not taxable. Is that the line? And then it becomes a question of whose proof it is, the states or the taxpayers?
Yes, absolutely. Yeah,
and in your case, the contract between Eisai and the specialty distributors restricts the specialty distributors to only sell Eisai's products to physicians and clinics and hospitals, if I understand correctly.
That's correct.
So they can't sell it to Walgreens under this contract.
That's right. The specialty distributors have to sell to parties that are licensed to resell. They can never sell to a patient. They have to sell to somebody that's going to resell. And this sales channel for these specialty cancer drugs, they're all sold through these smaller clinics, smaller oncology clinics. And the department did not, they really focused in their initial view of this case. They were not looking at this statutory interpretation, the statutory argument they're making to you today that this statute turns physicians into end users. They were focused on Rule 20 from the beginning of this case. And that's a rule that was promulgated in 1974. It states that hospitals and allied health service providers are the end users of items that they use in the course of treatment. Eisai doesn't sell to hospitals and allied health services providers. They sell to doctors and clinics. So Rule 20 is not relevant. Once we pointed that out to them during the course of briefing, they really backed away from Rule 20 and they pivoted to this statutory interpretation argument. The Chancery Court looked at the department's 1984. Tip on me. The department's 1984 interpretation of what that statute did. 1984, they put out this Tennessee Tax Quarterly. Every year they would publish this document describing the effect of legislation. And they wrote, 1984 Tennessee Public Act 563 amends 67-4-702 to provide that the sales of materials inserted or affixed to the human body or dispensed by physicians or dentists are exempt from business tax. They held these sales are exempt. And so the Chancery Court looked at this explanation and the facts in this case, and they connected the dots pretty simply. He said, department said these sales are exempt from business tax when drugs are dispensed during treatment. Eisai's drugs are dispensed during treatment by physicians, and so Eisai's drugs are exempt.
Does the department's quarterly report address whether this last sale is considered a retail sales transaction? Does it go into that subject?
This is the bulk of that description. So there's nothing more than them describing the impact of the law to provide that sales are exempt from business tax. But that is an answer to your question. They said that these, the impact is that sales are exempt. So it's still a retail sale. It's just an exempt sale according to the department's interpretation of the statute.
They wouldn't need to say it was exempt unless it was presumed to be a retail sale.
Exactly. So there are two ways to look at this matter, and in both ways, the court should affirm summary judgment for Eisai. Either, as the Chancery Court held, there's an exemption for drugs dispensed during treatment by physicians, and those drugs are always exempt throughout the chain, or there is an exemption when the doctor or physician makes that sale, and that is an exemption only at that level. But that's still, that doesn't have any impact on the fact that Eisai is still making a non-taxable wholesale sale. We made a wholesale sale to our specialty distributors. We made a non-taxable wholesale sale to our specialty distributors. They made a wholesale sale to the retailers. Retailers made an exempt sale to the patients. The department's interpretation of this statute, it wouldn't do anything other than move who pays the tax, and it's still going to be a cost that gets passed through to the doctors, passed through to the patients. Our interpretation.
Are you suggesting the initial interpretation or that department's bound by it, or that the court should afford deference to it? Do either of those come into play, or in this case?
They aren't bound by it, but it's certainly relevant that the department in 1984, the time this statute was passed, that's what they thought it meant. And so either it provides a blanket exemption for these drugs, or it provides an exemption at that retail sale level. In either case, Eisai is entitled to summary judgment. If it's just the latter, if it's that narrower reading, Eisai still made these non-taxable wholesale to wholesale sales. And in addition to that being the easiest interpretation, the most natural interpretation, that actually gives effect to the statute. I mean, the department, I think, is right in 1984 when they wrote this, because that actually gives effect to the statute. Instead of what they want to do now, which is just who pays the tax, we're actually giving some relief from this provision. Usually the legislature isn't going to do something just to change who pays the tax, and the tax still gets passed through to the doctors and the court, the doctors and the patients. Their interpretation and the interpretation we promote today still actually gives some effect to this statute, because there's actual tax relief for the drugs that are dispensed during treatment. The one other point that I want to re-emphasize, this is discussed at length in the briefing, but there are so many markers, both legally and factually, that back up the idea that Eisai's specialty distributors are wholesalers. The contracts which you mentioned, they require the distributors to sell to a provider for resale. They describe the sales in terms of wholesale acquisition costs. I'm sorry, can I?
If you'll finish, you can finish your thought,
okay.
but not develop a new one.
Understood. They require they describe the sales in terms of wholesale acquisition costs. Under federal law, the specialty distributors are defined as wholesalers. The FDA classifies them as wholesalers. Tennessee law also follows that federal definition, treats them as wholesalers. The Tennessee Department of Health classifies the specialty distributors as wholesalers. The National Association of Boards of Pharmacy describes them all as wholesalers. Eisai went and asked the specialty distributors how they reported for Tennessee business tax purposes, and they told us they reported as wholesalers. So you have all of these different markers. In addition to what we think is the natural reading of the statute, you have all these other markers that indicate all these parties should be treated as wholesalers for all kinds of factual and legal purposes. So for all those reasons, we think that the statutory interpretation.
Very, very good. Thank you. We'll now hear briefly from Mr. Carter. Good morning, sir.
Morning, Your Honors. Brett Carter of the Nashville Bar. I'm going to be addressing the constitutional issues in this case. We haven't heard a lot about those up until this point. But based on the holding of the trial court in this case on the substantive statutory issues, the lower court did not decide the constitutional issues. It just didn't get to them. The same, of course, would be true for this court if you affirm the holding of the Chancery Court or find for the taxpayer on the substantive statutory issues. There's no need to get to these constitutional issues. They need only be addressed if the court determines that the trial court's decision should be overturned. In that regard, the constitutional claims of Eisai provide a separate basis for this court to strike down the assessment that's at issue in this case. Eisai challenged both the manufacturing exemption and the personal property tax credit on constitutional grounds. In both of those exemptions and the credit are only applicable to in-state businesses. And so based on that particular status of those exemptions, they are discriminatory to out-of-state companies like Eisai. We've cited numerous cases in our brief related to the constitutional treatment of similar type of exemptions. U.S. Supreme Court cases. This court should only focus on the Armco versus Hardesty case. That's the primary case. It's almost directly on point. And it establishes that the particular exemption, the credit for personal property tax, because they only apply to in-state businesses, they're discriminatory and unconstitutional as applied to Eisai's business. Significantly, the state makes no effort in their briefing to really defend the constitutionality of those particular exemptions or the credit. They don't really argue it. All they argue is standing. They're saying that Eisai doesn't have standing, and the whole basis of that standing argument is whether Eisai had a business location in the state of Tennessee. And what we submit is that UPS facility that's owned and operated by UPS is not an Eisai facility. It's not a location. It's not an outlet. It's not a place of business of Eisai. They didn't have employees there. They didn't have a business address there. They have a contract with UPS, who is a contract carrier for them. Under the terms of that contract, it's termed a master service agreement. Under the terms of that agreement, UPS insures the property while it's at that facility. They don't own it, operate it. And so the department, in its own audit report, says that that location is a deemed location. And we cited that in our brief. It's not a location, Your Honor. And so the department is hanging its whole hat on the fact that Eisai has a location in Tennessee, but that is just simply not the case. They do not have a business location. There's no marker here. There's no lease of property. They cited two cases, and I'll end on this. They cited Westinghouse and Boeing. In both of those cases, the taxpayers at issue either had facilities, owned real property in the state, and Eisai has none of those markers. And so for those reasons, Your Honor, we think that the court should affirm the holding of the trial court.
One question, Mr. Carter. If we were to rule in favor of the Department of Revenue, the trial court correctly decided that it could not rule on the constitutional issue because it had ruled in your client's favor on the other dispositive issue. Would we need to remand the case to the trial court for the trial court to make an initial determination of the constitutionality issue, or do we just soldier on and address it ourselves?
I think this court can decide it, Your Honor. I think that when you get to the constitutional issues, I mean, determining place of business, I think there's possibly, when you look at the underlying pleadings in the case, that there may be disputed facts. This was decided on a cross motion for summary judgment. And so there may be some facts there. We certainly said that there was not a business location in the state. That was disputed by the state. And so there may be factual determinations that the trial court would need to make on that issue. That would be the sole reason that the court case, I think, would need to be remanded, Your Honor.
Very good. Thank you, Mr. Carter. General, you've got 3 minutes for rebuttal. What do you say is the relevance of your own client's interpretation of the 1984 Act?
Your Honor, I think that that this is a relatively short statement, and I think that you can it's open to interpretation in many ways. They repeat the statutory language, and then I think the statement is very unambiguous. And if, let's assume I'm correct about that, should I hold that against the department, or is it just a statement by somebody that's not relevant to the legal issue? I don't think it's relevant, Your Honor. What we're interpreting when we're engaged in tax litigation, we're not interpreting with the possible exception of regulations that have been made by the department, we're not interpreting the interpretations of the Department of Revenue. We're interpreting what the legislature intended when it created these statutes. And I do want to say there's been significant discussion of how the audit was conducted or the theories that underlie the audit. This is not a UAPA case. We're not reviewing the decisions that the Department of Revenue made. We're reviewing a trial court decision that was based on the facts and the law that was presented to the trial court. I do want to say that there is an essential oddity of Eisai's case, in which they are claiming that they get an exemption for drugs that were dispensed by physicians, even though Eisai does not dispense drugs, and as opposing counsel rightly emphasized, they're legally not allowed to dispense drugs to patients. The structure of their industry is set up so Eisai, and indeed Eisai's retail distributors, can never be someone who's affixing, inserting, or dispensing drugs to patients. So I think there's an inherent problem with their case, and they're claiming an exemption, who by its plain language could never apply to what Eisai does.
In general, opposing counsel reference, I believe, the Department of Health views Eisai as a wholesaler. Do we have a problem here in terms of an inconsistent position from the state in terms of Department of Health is saying they are a wholesaler and Department of Revenue is saying they're not a wholesaler?
Your Honor, the which statutes are read in pari materia depends on the structure of the statute. And it's established that the legislature can use a term in one place in the Tennessee Code that it uses in a different place somewhere else. And that's what we're dealing with here. Understandably, the Tennessee Department of Health follows the federal definitions because that's who they interact with. When we're creating a revenue statute, we're focused on a different set of considerations. The state set a situation where medical services are exempt from taxation, and we're trying to and the state's position is the whole function of this carve-out is to preserve that sort of separation of the provision of medical services from the business tax. I do want to say quickly that the business tax, ultimately, it's a replacement for the personal property tax on inventory. And it's about the business of making sales using that inventory. And what Eisai has done is they stored hundreds of millions of dollars worth of personal property in the state that they then transferred to people in this state. It's unclear. This is the making of business, and they should pay taxes on the fact that they chose to conduct a core element of transferring personal property in this state. Thank you, Your Honor, and if you have no further questions.
Thank you, and thank all three of you for your presentations. You've given us a lot to think about. Yeah.